Crime. It happens everywhere, from towns, cities, to countries. Offenders of the law are convicted and tried in a court, but in an age where international crime is a growing issue, how are international criminals dealt with? How are international laws established? It all started with the International Military Tribunal for the Far East, also known as the Tokyo Trials.
Before we can understand the Tokyo trials, we must explore the Nuremberg trials. The Nuremberg trials set forth a significant development in international criminal law. In previous years, there were attempts at regulating warfare and organizing international law. The Hague Conventions of 1899 and 1907 were some of the first legitimate declarations of the laws of war and war crimes. Although the conventions established that war is a crime, the conventions failed to establish any methods to trial or punish war criminals.
The crimes specified as crimes against peace are planning, preparing, initiating war, and the violation of agreements and treaties. War crimes include slave labor, killing hostages, or prisoners of war, destructions of cities, towns, or villages not justified by military necessity. Crimes against humanity include extermination, enslavement, deportation against a civilian population made upon political, racial, or religious grounds. The Nuremberg trials, however, were mainly a drastic reaction to the horrors of the Nazis, not so much a fair trial of the peers. Tokyo trials began May 19, 1946, and lasted 2.5 years. The 28 officials were tried for the offenses of leaders executing and waging for aggressive war, waging unprovoked war against China, waging aggressive war against the United States, British Commonwealth, France, Netherlands, USSR, inhumane treatment of prisoners of war, and disregard to prevent atrocities.
It's interesting how the principles established at the trials seem glaringly obvious. However, it is crucial to understand that international criminal law is an extremely new concept. This is where the Tokyo trials play a pivotal role. Beginning only 6 months after the Nuremberg trials, it would become the first test for the Nuremberg principles.
At the end of World War II, the Allies at the Potsdam Conference in July 1945 decided upon a trial to try those who have deceived and misled the Japanese people into fighting on the Pacific Front on the side of the Nazis. General Douglas MacArthur was appointed Supreme Commander for the Allied powers. He was in charge of rebuilding Japan, but also the Tokyo trials. Nearly 5,000 Japanese were tried in smaller courts by other Asian countries victimized by the actions of the Japanese army. 39 officials of General Hideki Tojo's cabinet were arrested. 28 were to be tried in Tokyo trials under General MacArthur.
Tokyo trials began May 19, 1946, and lasted 2.5 years. The 28 officials were tried for the offenses of leaders executing and waging for aggressive war, waging unprovoked war against China, waging aggressive war against the United States, British Commonwealth, France, Netherlands, USSR, inhumane treatment of prisoners of war, and disregard to prevent atrocities. The Tokyo trials were broken up into broad categories: Class A, B, and C. Class A were leaders who planned and directed war. Class B and C were for any rank and tried for conventional war crimes and crimes against humanity. All were guilty. 2 died during the trials, 2 to lesser terms, 16 life terms, 7 sentenced to death. Of those 7 was Hideki Tojo.
Tojo was found guilty for all charges brought against him. He was hanged 2 months after his trial.
Go.
The Nuremberg principles were specifically created for the prosecution of the Nazis. The Tokyo trials became solid proof that the Nuremberg principles allowed flexibility in its application in other cases. It presented that other tribunals had the ability to uphold the same possible prosecutions for crimes against humanity. In other words, Tokyo was the first major stepping stone for international law. It universalized the Nuremberg principles and made them applicable to other situations by precedent. Additionally, it popularized terms, crimes against humanity and peace. With the Tokyo trials came the universal principles and systems that would become the base of future international.
For years to come, the Nuremberg and Tokyo trials were the only examples for international criminal courts. They served as models and ushered in a new series of international criminal courts that began in the 1990s. In 1992, Bosnia-Herzegovina declared its independence from Yugoslavia. This heightened the ethnic tensions between the Serbs, Bosnians, and Croatians. For the next several years came the genocide of 100,000 Bosnian Muslims and Croatians at the hands of the Serb-dominated Yugoslav army. In response, the UN Security Council established the International Criminal Tribunal for former Yugoslavia. The ICTY officially convicted 161 individuals, including the former Serbian president Boris Tadic, for crimes against humanity. However, there's a darker side to the trials. People have strongly criticized the manner of these trials. Often it's considered an example of victor's justice. In both trials, the victors conducted a trial as defeated nations were tried. Hans Kelsen, a famous European theorist, stated that it was more of a council of worldwide political governments rather than a court of justice. Clearly, courts were unnatural as they worked against the defeated nations. Due to the lack of evidence, the Tokyo trials used a method called best evidence rule, which allowed secondary claims to be made without official verification. Due to this, the Indian justice Radha Pal found that the court was plagued with victor's justice. Furthermore, none of the victors faced trials for mass civilian killings such as firebombing cities and the use of 2 atomic bombs. Saddam Hussein's trial received the lasting fear of victor's justice and the weakening precedents of the Nuremberg and Tokyo trials. Saddam Hussein led an invasion of neighboring state Kuwait. This prompted a reaction from the UN. With authorization from the UN, an American-led coalition immediately began to bombard the Iraqi military. However, the UN Security Council punished the population of Iraq as a whole by creating economic sanctions. There was an absence of a UN-authorized court to punish the actual perpetrators for crimes against humanity. The civilian population, which had no control over the actions of the government, were punished, while Saddam Hussein remained at the top of the government. While George W. Bush's motives in Iraq was to establish a democracy. Due to this, one objective of the court was to be free of political influence and manipulation. However, because of America's dominance in international law, the tribunal was left in the hands of the Iraqi Special Tribunal instead of an international court. Allowing the Iraqis to lead the court avoids the imperialistic nature the American court would have. However, this created much speculation. It was unclear whether or not the Iraqi legal professionals had the resources or expertise to conduct such a complex case. Furthermore, it was unknown if the court would adhere to international standards of human rights.
With World War II came the globalization of crime on a scale never seen before. With this came the need of laws that will regulate crime at an international level. These laws are still evolving and will eventually punish all those who commit crimes against humanity.
The crimes specified as crimes against peace are planning, preparing, initiate. Stop.
God damn it.
In order to try the. God. Alright. In order to. Okay. In order to try. Okay. In order to try the. God, I had it right. Okay. In order to try the Nazis, numerous principles were set in place establishing that violators of international crime are subject to punishment. Can I just say of the Far East? Are you, don't put this in.